The motion for recusal, maybe it's just as scandalous as the motion for a new trial with all of the things that have been going on that are diabolical behind the scene. And Karmelo Anthony's new team is not playing. They don't want Judge Roach to even glance or breathe on any of the motions that they're filing. They don't want him presiding over the hearing that has to be done before they get to the appeal, and they for sure don't want him presiding over the new trial at all. But Judge Roach has responded, and his response is, I refuse to recuse. Baby, we about to get into it all and pour it up.
Big poppin', money in the bank coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me big poppin'. Money in the bank coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me what the tap is.
What's poppin', everybody? It's your favorite guys and Dr. That Girl, Henny, and today we are going to be pouring up on the motion to recuse Judge Roach from Karmelo Anthony's case. But in the meantime, if you are new here, please be sure to lean on the like, okay? Be sure you lean on that like. Be sure you subscribe and click that notification bell so that you can be notified whenever I do a video. And be sure you select all as well. But if you are a returning Mob Down Henny Gang member, now let's pour it up. So as we all know, the motion to recuse was put in, the motion for a new trial has put in, and we've already gone over a majority of the motion for a new trial. And baby, that thing was long and we was on late at night, and yeah. I was getting sleepy reading. It was a lot. It was a lot. But we breaking it all down. And today I am back with another video. And this time we are getting all up into the motion to recuse. Because this is the document we want right here. This document, and I know y'all are probably like, well, Henny, it's probably going to sound the same as the new motion. But here's the thing, right? This focuses strictly and solely on why they want Judge Roach off of this case. They do not want, and by they, I mean Karmelo Anthony's team and Karmelo himself, because understand his lawyers can't do anything without him giving the okay. So they do not want Judge Roach presiding over this at all. And yes, baby, this is the document that was filed on the same day as the new trial motion. Okay, so let's get into it without further blah blah blah, and I'm leaving that in without further ado because we've got quite a few pages to run through. All right, so it says, to the honorable judge of said court and to the presiding judge of the administrative judicial region. Come now, defendant Karmelo Sincere Anthony, by and through the undersigned counsel, and pursuant to Texas Rule of Civil Procedure 18A, 18B, respectfully moves to recuse the Honorable Judge Roach from presiding over the post-trial proceedings in this cause, including defendant's motion for a new trial and brief in support of the defendant's objection to the closure of the proceeding and any continued restriction of public access, and motion for evidentiary hearing to clarify the record of appeal, both filed contemporaneously with here within. In support, Mr. Anthony shows the following. So, like I said in the intro, they don't want Judge Roach presiding over anything. They don't want him looking at any of these documents. The evidentiary hearing is actually the gentleman's deal that they did. Because if you watched the video that I did, let me get that up here on the screen for y'all really quickly. If you watch this video right here, former Karmelo Anthony attorney blows the lid off secret gentleman's deal, then you know exactly what we're talking about. But if you have not watched it, then you need to go back and watch it so that you can catch up, mustard. But basically, what they're saying in the new trial, and they're going to probably go into in this one too, is the fact that, and I mean the motion for a new trial, is that this gentleman's deal, it was done in the judge's chambers. Okay, if you, Mike Howard hand delivered it in the chambers to the prosecution. So there's no record, and there's no record of a lot of things that have gone on in this case in pre-trial. Okay, pre-trial motions are not there. And I'm going to show you better than I can tell you. And they also want the restriction of public access lifted off of this case. Now, that was put into play before the trial even began. And Judge Roach said that it was to keep some of the rumors from running out of control and tainting the jury. But here's the thing about the internet that I don't think courts are realizing. If you don't give up the evidence, if you don't tell us what's going on, then you're going to have a lot of rumors and speculation. People are going to be side-eyeing because, baby, we don't trust just the word. We need to see it like we see in this in black and white. We need to see what's going on. Plus, there was limited access for press and general public to get into the court because if you remember, I had explained that there was 70 seats in the courtroom with 30 of them supposed to be going to the family. But if you remember from the doc read from the motion for the new trial, 15 seats were supposed to go to Karmelo Anthony's family, and 15 seats were supposed to go to the Metcalf family. However, Karmelo Anthony's family ended up only getting 8 seats. And if you want me to do a standalone video about the seating and all of that, drop some 8s down in the chat, and I will make sure I get you that ASAP, baby. But we're going to continue on with this motion to recuse because, yeah. It's a good one. Now they get into the timelines and the procedural posture, okay? And it says that a jury found Mr. Anthony guilty of murder on June 9th, 2026. The court imposed sentence in open court, assessing 35 years confinement. Contemporaneously with this motion to recuse, Mr. Anthony has filed defendant's motion for new trial and brief in support and defendant's objection to the closure of the proceedings and any continued restriction of public access and motion for evidentiary hearing to clarify the record for appeal. Those filings require fact-finding concerning the court's access order, courtroom capacity, public seating, overflow access, record restrictions, and the court's post-trial public statements. A notice of appeal has been filed. The grounds for this motion to recuse arose after trial and are set forth below. So basically, they're just reiterating, this is what we filed. Okay, these are the things that we're looking for. They want fact finding concerning the court's access order. They want, the courtroom's capacity. Like, what is the courtroom's capacity of people? They want the public seating. They want the overflow access. They want everything, baby. Okay, they want to know about the record restrictions and they want the record restrictions lifted as well. Now, this court retains authority over the post-trial proceedings. A notice of appeal does not divest the trial court from jurisdiction to conduct post-trial proceeding. Excuse me. Let me rewind. Come down, selector, and do that one again. This court retains authority over the post-trial proceedings. A notice of appeal does not divest the trial court of jurisdiction to conduct post-trial proceedings, including a hearing to settle and clarify the record and a timely motion for a new trial. That authority continues through the 75th day after sentencing and until the appellate record is filed in the Court of Appeals. Okay, because the Honorable John Roach is the judge who would preside over the requested evidentiary hearing and rule on a timely motion for a new trial, recusal is properly sought now. Okay, so basically, in a nutshell, they are on the clock right now. Okay, the trial ended back on June 9th, and they're on the clock. So the defense had 30 days from the 9th to file their appeal, the motion for new trial, and the recusal. And what you have to remember has happened is after the trial was over, the next day, Karmelo Anthony's defense team filed the appeal for him. And then he had a court-appointed lawyer assigned to his case. From the court-appointed lawyer, he then got the 6-person dream team that's working pro bono for his case, for him on his case, I should say. And so now, with all the changing of hands and changing of guards, These lawyers are working under the clock, and they got this in by the nick of time. Okay, the appeal is in. All right. They've got the motion for the new trial in and the motion for the recusal in. And now the courts have 75 days to get this ball rolling for them to have a hearing, for them to even see if this is worth having. I believe it's a new trial, or for them to have I think it's for the new trial. Don't quote me on that right now, but they don't want Judge Roach to be a part of any of the proceedings, given how he presided over the case in the first place. Okay, this motion is timely. A motion to recuse must ordinarily be filed at least 10 days before the hearing at issue, whereas here, the grounds for recusal arise after trial. The motion must be filed at the earliest practicable time after the movant learns of them. Okay, so they had to do this within a practical time of everything, and being that they just got on the case, I think that this is practical. And I said movant, it's movant. Okay, so the motion must be filed at the earliest practicable time after the movant learns of them. Okay, movant learns of them. All right, so it says the motion must also be verified and must state with particularity the grounds why the judge should not sit on personal knowledge and set forth fact that would be admissible to evidence. Okay, this motion satisfies each requirement. The undersigned counsel entered an appearance in this court on June 23rd, 2026, and first became aware of the interview described herein on that date. This motion is filed at the earliest practicable time thereafter, before any hearing on the motion for new trial has been set or held, and before any ruling on that motion. So basically, they learned about the interview after they joined on to the case, and they have filed this motion within a timely manner. All right, so here are the grounds for recusal. It says, after the jury returned its verdict and the court imposed sentence on June 9th, 2026, the Honorable John Roach, the presiding judge at trial, granted a televised interview to WFAA-TV Channel 8 concerning this case that aired on or about June 11th, 2026. So, Karmelo was sentenced and the trial was over on June 9th. And Judge Roach, on that same day, granted permission for a television interview. So that was right after the trial that happened. And then it aired on or about June 11th. Ooh, scandalous. In that interview, Judge Roach expressed personal opinions about the propriety and the correctness of the jury's verdict, the fairness of the trial, and the correctness of the judge's own ruling during trial. Such conduct implicates the Texas Code of Judicial Conduct and the objective appearance standard rule under 18B. The case remains a, quote, pending or impending proceeding, end quote, before the court at this time, and public statements expressing the judge's personal views on these matters would suggest to a reasonable person that the judge's probable decision on any motion for a new trial that may be filed, recusal, is therefore necessary. Let me take these off real quick. Not that I don't need them, because I do, but let me read that one more again for y'all, okay? So because he did that interview, what Karmelo Anthony's people are saying is such conduct implicates the Texas Code of Judicial Conduct and the objective appearance standard rule of 18B. This case remains a pending or impeding proceeding, meaning it's still ongoing. It hasn't stopped. Before the court at this time, before the court. The public statements expressing the judge's personal views on this matter would suggest to a reasonable person the judge's probable decision on any motion for a new trial that may be filed. Meaning, because he backs up what the jury said, because he stands by what he's done in the trial, That's going to let you know that Judge Roach will give the same verdict again, and Karmelo will not get an impartial judge or an impartial jury, and he will just get a repeat trial instead of a new trial. And so this is why they're saying that Judge Roach needs to step the hell down, okay? Among the problematic comments that Judge Roach made during the WFAA-TV interview are the following. Y'all ready? I just have a problem with my glasses being on my face because I'm really not accustomed to them being on my face, so they bother me. And then they're progressive, so they got like this tint to them, and that kind of bothers me. But whatever, let's continue. A, Judge Roach endorsed the jury's guilty verdict. When asked by a reporter, did the jury get it right? Judge Roach asked, yeah, they did, explaining that jurors were picked based upon the law and listened to the facts. That happened here in this very courtroom, and added that whatever they say, they get it right. B, Judge Roach characterized Mr. Anthony as a nice guy who committed a crime, who understands today the consequences of committing a crime like that. He did. And declared that Mr. Anthony had received a fair trial, stating, I certainly think he did. Judge Roach defended the courtroom access and no streaming restrictions that the motion for new trial challenges, calling the decision not to allow cameras and streaming an easy decision, asserting that the general public had access to the courtroom, stating that of the 70 seats in the courtroom he had 200 requests by media, and that the public had only 27 to 32 public seats that were rotated every day, maintaining that members of the public could have stood in line with everyone else to obtain one, and concluding that he had struck the balance pretty well. You didn't. Because see, here's the thing. Like they said in the motion for the new trial, there was no overflow room. See, in order for this to truly be a public trial, you have to make it accessible to the to the public. Yeah, so that means having more than one overflow room possibly, so that you can accommodate the people that are coming in that couldn't make it into the courtroom. That's what most courthouses do, okay? Judge Roach addressed a suggestion, then circulating Judge Roach addressed a suggestion, then circulating in social media, that he had a personal relationship with the family of the deceased, denying that he knew the Metcalf family, disputing the authenticity of the image said to show otherwise, which appeared to have been fabricated, and volunteering that he sympathized with the Metcalfs and what they were going through. So that shows that he has a bias. I mean, you can sympathize with somebody, but as a judge who knows that there's going to be an appeal, because you had to have known there was going to be an appeal, you're making a comment like that, it's giving bias. You can't say stuff like that. Hello? Is this what they do in Collin County? I'm just asking. No offense. All right. Judge Roach addressed his ruling during jury selection. When asked about the defense's objection to the dismissal of 3 prospective jurors who had identified as African American, Judge Roach stated that he followed the law in that case, quote unquote, and did it to the T, quote unquote, that he was, quote unquote, proud of that. And that although he, quote unquote, knew in the back of his mind what the perception was going to be, he was, quote unquote, not here to satisfy perceptions. So again, you're showing that you would give a repeat trial. Judge Roach reiterated the public defense of his own ruling in a written statement to Fox News, in which he states, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency. Transparency, huh? Transparency. Oh, there's a whole lot of secrecy still going on in this case, though, but it's transparent. Have you noticed that people like to use that word transparency a lot nowadays, but seem to not know what transparency actually means? Mm-hmm. A verified transcript of the interview is attached as Exhibit A. The recording of the interview is filed conventionally with the clerk as Exhibit C, and Judge Roach's written statement to Fox News is attached as Exhibit D. Oh, we have the exhibits that are attached to this too, all right? Now, throughout the trial proceedings and in ordering prohibiting extrajudicial statement, the gag order, because remember, everybody was under a gag order, entered on July 28, 2025, barred every other participant in this case, all parties and their attorneys, witnesses, experts, consultants, agents, and spokespersons, and law enforcement personnel, courthouse and court staff, and court-appointed officials from making any extrajudicial statements that address the character, credibility, expected testimony, guilt, or innocence of any party or witness that discusses the anticipated evidence or that it intended or likely to influence public opinion. So nobody was allowed to open their mouth. So it wasn't just the Metcalf and the Karmelo Anthony family. It wasn't just the Anthonys and the Metcalfs. It was the attorneys. It was the bailiffs. It was the clerk's office. It was everybody and anybody who was going to touch this case or participate in that courthouse in the case that they had a gag order placed on them. They weren't allowed to say shit. The court grounded that restriction in its own findings that extrajudicial publicity posed a risk of imminent and irreparable harm to the right to a fair trial. So they did that to preserve Karmelo's right to a fair trial, is what they are saying. That's what Judge Roach is saying, that he did it to preserve the fair trial. By its terms, the gag order governed the proceedings through the conclusion of the trial. The court's interview followed sentencing, and Mr. Anthony does not assert that it breached the order. What matters is not any breach, but the principle the court itself announced in entering the order. That public commentary on a pending criminal proceeding threatens the fairness of the proceeding. The gag order is attached in Exhibit B. We're going to read said gag order. So basically what they're saying here is, you place the gag order on anybody from being able to taint this trial, but you go immediately after this trial and you do an interview. And by the time the interview is aired and this letter goes out, it's after Karmelo has already filed his appeal. So the very thing that you were trying to stop everyone else from doing, you just went out there and did. The same judge who imposed silence on the defense, the state, and all other participants on the express premise that public commentary threatens a fair proceeding, thereafter spoke publicly about this case, endorsing the verdict he has been asked to set aside and defending the access ruling now challenged, all while retaining the authority to preside over the post-trial proceeding still before him, including the requested evidentiary hearing and timely motion for a new trial. So you went and did all of this. You went and poisoned the public with your interview, and you still got to preside over this case. And while you poison the public, you stand on what you did, what you said, what happened in the court, the way that it went down. You're standing on that. So you cannot sit over. He got to step down. You can't trust it. Oh, no, no, no. And his contemporaneously filed objection and motion for new trial, Mr. Anthony contends that the management of courtroom security and capacity led to the denial of a public trial. Judge Roach's own public statement reflects substantial personal involvement in the logistics and access decisions now at at issue. In his post-trial WFFA interview, Judge Roach stated that he had been quote unquote prepping for this trial when with county departments, the Collin County system, the sheriff's office, and others, quote unquote, for about 8 months. In his June 17, 2016 public letter, Judge Roach described the involvement of multiple county agencies and offices in the trial's logistic administration. These facts reinforce why another judge should decide the post-trial motions based on documentary evidence, testimony from non-judicial witnesses, and a record made in open court, rather than requiring the respondent judge to evaluate the level effective of his own dispute. And a record made in open court, rather than requiring the respondent judge to evaluate the legal effect of his own disputed public explanations and access-related decisions. The interview was not Judge Roach's last public word on this case. On June 17, 2026, after sentencing, while the court retained authority to decide a timely motion for new trial and the cause remained subject to direct appeal, Judge Roach published a signed public letter about this prosecution on Collin County's official government website under the title, "Thank You Letter from Judge John Roach." Yes, he did. I know y'all sitting back saying, no, he didn't. And I'm sitting up here telling you, yes, he did. Matter of fact, I take it back. Yes, the fuck he did. Okay? And we got that letter too. Okay? It's part of the evidence. We got it. Okay? Addressed to the members of the Collin County family. So, you're addressing the public. The very same public that would have to be picked for a new trial. The very same community. Child. Judge Roach speaks of the recent trial of the state of Texas versus Karmelo Anthony as a finished undertaking and closes by calling the service, quote, "one of the greatest honors of my judicial career," end quote. Judge Roach further tells the public that those who worked on the case contributed to ensuring that the process was conducted fairly. Were we watching the same trial or not? Don't worry, I won't wait. The very question, a motion for a new trial challenging challenging the conduct of the trial would put before the court to decide. A judge who publicly memorializes the trial as concluded and publicly pronounces the process fair, while still holding the authority to grant a new trial, signals to a reasonable observer that he regards the matter as closed. Done deal. Ain't happening. Okay? That Judge Roach did so once more in a public forum after having used the gag order to restrict every other participant's public commentary throughout trial, sharpens rather than softens the appearance that the court no longer sits as a neutral arbiter of the post-trial proceeding that remains before it. Which is true, because if he's sitting up here saying, oh, well, thank you to everybody, like you doing your victory lap. He did everything but this. He did a victory lap, a ticker tape parade, and all of that for himself, considering the matter to be done and over with, ladies and gentlemen, boys and girls. That's what he considers it. Over. I said what I said. I did what I did. What happened, happened, and it is what it is. That's what he's giving. He can't be impartial. I don't see how anybody that looks at this from a level of legalities, is that okay? Am I being, anyone that sits and reads this, I don't see how they could possibly keep him on as the judge. Anyway, so standard in argument, a judge must recuse where his impartiality must reasonably be questioned. Okay, a judge must recuse in any proceeding in which the judge's impartiality might reasonably be questioned, or in which the judge has a personal bias or prejudice concerning the subject matter or a party, which, I mean, what did Cardi B do when she was in the trial? She was like, that's how we all sitting here like, These procedures apply to criminal cases, okay? The standard is objective. The question is not whether the judge is in fact biased, but whether a reasonable member of the public at large, knowing all the facts in the public domain concerning the judge's conduct, would harbor a reasonable doubt that the judge is impartial. I am a person of sound mind and body, as are all of you who are watching this, and I say that he cannot be impartial because he has already picked a side. He has already shown that he cannot be non-biased to himself. Okay? Now they bring in a bunch of cases. All right. Applied here, a reasonable observer aware that the presiding judge during the Rule 21 period in which a motion for a new trial could be filed and before his authority to rule on a timely motion expired, gave a public television interview endorsing the verdict and defending the challenged access ruling, the very matters a timely motion for new trial would ask him to set aside, would reasonably doubt that the judge could impartially decide the motion. The objection is not that the motion for a new trial challenges the court's ruling. Every such motion does. It is the court's publicly vouched for correctness of those specific rulings outside the courtroom before it was called upon to decide the motion. Basically, he had no damn business taking no interview and writing no damn letters the way that he did, because it was not over. It was not over. Karmelo still had time to file an appeal. The appeal had not been denied. So the case is still open. Now, had this been now, where it's July 9th, the 30 days to file for an appeal, a new motion, and all of that has expired as of today. So if said interview came out on July 11th, we wouldn't be sitting here right now because he would have missed the deadline for an appeal. Then the case would be over. So he didn't even give the case a chance to breathe. He just declared it a done deal, okay? The court's extrajudicial public commentary on this case requires recusal. Okay, the basis for this motion is the court's extrajudicial public statements about the case, not its ruling. Under Rule 18A, a judge ruling may not be the sole basis for recusal, but the comment to the 2111 amendment makes clear that the terms rules is not meant to encompass a judge's statement or remarks about a case. Bias or prejudice arising from extrajudicial sources is a common basis for recusal, okay? The question, however, is not whether the court learned the facts of the case from a source outside the proceeding. It is that the court made extrajudicial public statements that objectively appear to commit it to the verdict and the challenged access ruling, while it still retained authority to decide a timely motion for a new trial, attacking those very matters. The contrary limitation that a judge's in-case ruling, remarks, or actions will only rarely support recusal has no application here, because the ground is not anything the court did in the courtroom, but what it said about the case outside of it. So what they're saying is we're not attacking his ruling. We're not attacking even his courtroom conduct. We're attacking everything that he did outside the courtroom that was based on what happened in the courtroom, everything he said and did that pertained to this case outside the courtroom. Okay, where the principle that an extrajudicial source supports recusal has been applied to a judge's public commentary about a pending case, courts have required disqualification as set below. So in other cases where judges have done similar things, they were disqualified from being able to preside over the case any further. Okay. More pointedly, the court publicly defended its very own courtroom access restriction that Mr. Anthony challenges as having denied him a public trial, the subject of his contemporaneously filed a request for the evidentiary hearing and motion for a new trial. The court has now publicly characterized the same restrictions as proper and asserted that the public had access to the courtroom. The court would thus be required to rule on a challenge to its own ruling after publicly committing in the media to those rulings' correctness. A reasonable member of the public, aware of these facts, would harbor far more than a reasonable doubt that the court could impartially decide that challenge. Now, if you don't believe that the judge would be able to rule against something that he publicly committed himself to, a ruling that he has publicly stood on, if you do not believe that Judge Roach would be able to rule against his own bullshit, put reasonable doubt down in the comment section or NR. Because if you have reasonable doubt, then you are part of the people that he's talking about in this thing here, okay? You're part of the public aware of these facts, okay? And you're a reasonable member of the public. But let's continue. Nor was the court's public defense of its ruling limited to the access restrictions. The court also defended its ruling during jury selection, declaring that it followed the law and did it to the T, that a judge would take the media to vouch for the correctness of his own contested ruling. While review of those rulings remain to be sought, it is at the core of what the objective standard forbids. Those access rulings are not merely challenged. A public decision of the very court that reviews this one has since held that a comparable space-based closure of jury selection imposed without Waller findings or consideration of reasonable alternatives violates the right to a public trial and requires a new trial. Okay, that the court publicly vouched for the correctness of the ruling, now challenged under recent published public trial authority from this Court of Appeals, only sharpens the appearance that it has committed itself outside the courtroom to a position that it must now revisit. Okay, in other words, you know you done fucked up, right? You know you done showed your hand too tough. I'm waiting to see if Jeff Metcalf is going to get on another video and talk about how the judge fucked it up, like how he said they did for the video. The court also publicly endorsed the correctness of the very verdict the motion for new trial asked it to set aside, stating that the jury reached the right result and that Mr. Anthony committed a crime. A judge who has publicly proclaimed the verdict correct cannot be expected to impartially decide a motion seeking to set aside the verdict, set aside that verdict. Wait a minute, I jumped ahead of myself. Okay, a judge who has publicly proclaimed the verdict correct cannot be expected to impartially decide a motion seeking to set that verdict aside. There we go. The standard that governs judicial public comment confirms the appearance problem. The code of judicial conduct provides that the judge shall abstain from public comment about a pending or impending proceeding which may come before the judge's court in a manner which suggests to a reasonable person that the judge's probable decisions on any particular case. That's it. Let me read that again. I'm having some technical difficulties here. I'm sorry. Let's rewind. The standard that governs judicial public comment confirms the appearance problem. The Code of Judicial Conduct provides that a judge shall abstain from public comment about a pending or impending proceeding which may come before the judge's court in a manner which suggests to a reasonable person the judge's probable decision on any particular case. Although that canon does not bar a judge from explaining court procedures for public information, this is not a neutral procedural explanation. The court endorsed the verdict, stated that Mr. Anthony had committed a crime, declared the trial fair, and defended the very access restriction Mr. Anthony now challenges. That principle reflects the same concern that drives the recusal inquiry. The public confidence requires a judge not appear to have resolved outside the courtroom a matter still before him. Mr. Anthony does not contend that the court should be disciplined. The point is narrower. The court's public endorsement of the verdict and defense of the challenged ruling on a matter that remains pending with the post-trial proceeding yet to be decided, the case subject to appeal is precisely the kind of comment a reasonable observer would understand to signal the court's review of the very questions it may now decide. Now, this is going over, it's basically saying the same thing over again. You know, we're not asking, basically they're saying they're not asking for him to be punished. They just don't want him to decide. And they're backing up and driving home the fact that this judge can't preside over it. He's violated. He has violated codes. He violated the Code of Judicial Conduct. Okay? So he has to go. So if he stays, we know some fuckery afoot for real again. All right. Recusal does not turn on labeling the court's conduct a breach of any rule. It turns on the objective appearance standard. Mr. Anthony does not rest on any rule violation. A violation of a canon of judicial conduct will not, standing alone, support recusal absent of requisite of the requisite showing. The controlling question is objective. Whether the court's extrajudicial public commentary would cause a reasonable member of the public to doubt the court's impartiality. Under that standard, the court's public commentary is strong evidence on the appearance inquiry under Rule 18b(b)(1). The asymmetry lies at the heart of this motion. By written order, the court found that extrajudicial publicity posed a threat of imminent and irreparable harm to the fairness of this proceeding, and on that finding, it silenced everyone to the stake of the case. The parties and their counsel, the witnesses, and even law enforcement personnel, court staff, and the court-appointed officials who spoke for the court. Then, with every participant bound to silence by the court's own command, the court alone stepped before the cameras and spoke at length about the very case it continues to adjudicate, endorsing the verdict and defending the challenged ruling. A judge who declares public comment on a case so dangerous that all others must be silenced, and who then reserves that commentary to himself while the case remains before him, does not appear a reasonable member of the public does not appear to reasonable member of the public as a neutral arbiter of the law. That asymmetry standalone cast reasonable doubt on the court's impartiality in deciding the pending post-trial matter. So again, they're saying you stopped everyone else from talking. Everyone else was bound by this gag order. And then you, the very person who bound everybody by gag order because their words could be so dangerous and detrimental, you went out and you violated and you spoke. Well, they're not saying he violated, but he decided to speak instead. Okay? The federal courts applying the analog appearance standard of 28 USC subsection 455A have treated a judge's public comments on pending newsworthy litigation as a serious recusal problem. Okay? So at the federal level, it was a serious recusal problem. All right? And they cite cases where it shows this was a problem. All right? Those decisions describe this case. A judge who granted a televised interview about one of the most closely watched prosecutions in the state, endorsing the verdict, pronouncing the trial fair, and defending the very access ruling under review, has assumed the posture of an advocate for his own judgments rather than a neutral arbiter of the motion that challenges them. Okay? Mr. Anthony's conviction is now pending on direct appeal before the Court of Appeals for the 5th District of Texas at Dallas. The trial retains lawful authority over a timely motion for a new trial, withstanding the notice of appeal. Okay? The appearance problem is therefore not one of jurisdiction. Mr. Anthony gave notice of appeal on June 10th, the day after sentence was imposed, and before the court sat for its televised interview. Well, with that appeal already initiated and before any appellate brief was filed or any reviewing judge had written a word, the court went on television and pronounced its own ruling correct and the verdict sound, reviewing and affirming its own decision in the court of public opinion ahead of the very courts to whom that review belongs. A trial judge's public review of the merits of his own rulings while the court retains jurisdiction with the post-trial proceeding yet to be decided, that the notice of appeal on file, no brief yet written, and no appellate judge having spoke, underscores why a reasonable observer would doubt that the court could now impartially preside over the post-trial proceedings, including a timely motion for a new trial. A reasonable member of the public would regard a judge who publicly vouches for the correctness of his own judgments, while those judgments await the considered review of a higher court, as having exchanged a neutrality of the breach for advocacy for his own work, and would doubt that the same judge could impartially preside over the post-trial proceedings to remain before him. The need for recusal is brought to a point by the proceedings that now lie immediately ahead. Mr. Anthony has objected to the sealing of the court file and has asked the court to convene an evidentiary hearing to establish for the record and for appeal. Now the trial was structured and closed, and how, when, and by what authority the court file and the reporter's records were sealed and withheld. Those are inquiries into the court's own conduct. The judge who imposed the closure directed the sealing, then publicly defended both would be asked to preside. Hold on. Those inquiries into the court's own conduct, okay? The judge who imposed the closure directed the sealing and then publicly defended both would be asked to preside over a hearing receiving evidence about the propriety of those very acts. Property, excuse me. Sorry, I stumbled on the. Okay, the judge who imposed the closure, directed the sealing, and then publicly defended both would be asked to preside over a hearing receiving evidence about propriety of those very acts. and in the motion for a new trial to follow, to decide whether they require a new trial. A reasonable member of the public would doubt that the same judge could sit impartially at the fact finder on the lawlessness of his own challenge decision. The doubt is itself reason to refer this matter so that a different judge can conduct the hearing and decide the motions that depend on it. There is further dimension to the court's public commentary. In taking its defense of its own ruling to the press, the court spoke not as a private citizen, but as the authority of judicial office, leading the authority to a one-sided public account of a case it must still decide. The effort is to convert a matter committed to orderly adjudication in a public contest, one in which Mr. Anthony must either answer the court in the media or allow the court's public endorsement of its own ruling to stand unrebutted while the same court continues to preside over the motion challenging them. A reasonable member of the public would regard a judge so situated as a neutral arbiter the law requires. They would not regard the judge so suited as a neutral arbiter of the required law. Now, prior to that, they went into mentioning about how the court records. Now, if you read that, if you sat through me reading Mike Howard's affidavit, sworn affidavit, then you know that the records are sealed under oral seal and sitting in the judge's chambers. You would also know that the court record, the recorder, the stenographer, the stenographer's notes have not been transcribed. So there's no transcripts to the trial either. Okay? Mr. Anthony does not allege that the court had any relationship with the family of the deceased. The social media material suggesting such a relationship appears to have been fabricated, including by artificial means. The point is not the truth of that suggestion, but the court's response to it. Rather than allow a non-record rumor to remain outside the proceeding, the court used its televised interview to answer a suggestion of its own partiality that no party had raised, denying any relationship with the family and, in the same setting, volunteering that it sympathized with the Metcalfs and what they've been through. In stepping before the cameras to defend itself against the extrajudicial allegations and to express sympathy for the family of the deceased, while the Rule 21 period remains open, post-trial relief was impending, and the court still retained authority to gain a new trial, the court assumed the posture of a participant answering a charge rather than a detached adjudicator. So while he thought he was doing something by saying that he was distancing himself from the family and not knowing them, you actually added more problems for yourself and more reasons as to why you need to be removed. Because at the end of the day, how are you going to sit up here, call Karmelo a criminal? Okay, number one. Number two, say that the jury got it right. Number three, stand on it. Number four, say that, you're picking for jurors was correct, true, and accurate, and your heart goes out to the family. I just can't get over that. But yet you're supposed to sit here and impartially be able to rule over a new case, a new trial for a case that you already considered to be closed and done. Absolutely not. The governing question is observed whether the court's conduct viewed by a reasonable member of the public convey, quote, an uncommon interest and degree of personal involvement, unquote, in the case. I say, as a person, a member of the public, that he needs that he needs to be recused. Okay, a judge who goes on TV to deny a personal allegation and to express sympathy for one side's family while the Rule 21 period remains open and post-trial relief was impending conveys the very personal involvement that decisions describe. Okay, so here's where we're getting into, because remember when I had told y'all why they would ask for a recusal. Okay, and it's for conflict of interest, prior personal involvement, or explicit bias. He just made himself personally involved in the case by doing this. Okay, he just made himself personally involved by making that statement. He already showed that it is a conflict of interest for him to preside over this trial again, because, or to even hear anything that goes on with this case, because he stands on his shit. And I would say that goes as far as to be biased himself. Okay, this ground is of a piece with the closure it accompanies. The court's sealing of the record and its restrictions on public and press access creates the information vacuum in which such rumors could take hold. The court then used the press access it had reserved both to refute the rumor and to re-justify the access restriction that produced it. The obstructive appearance is of the judge managing the public narrative of his own case from both directions. Standing alone, this thread is the most modest of grounds stated above, and Mr. Anthony presents it not as an independent bias for recusal, but as confirmation of the personal involvement and want of detachment that the court's endorsement of the verdict, its defense of the challenged rulings, and the public's view of its own judgments already established. So they may not want to call it personal and biased and looking at it as personal involvement. I call it biased as well. Okay. The court need not reach constitutional due process, Rule 18 BB1. One's objective appearance standard is sufficient. Due process confirms the importance of an impartial decision maker and the principle that recusal is required where the probability of actual bias is too high to be constitutionally tolerable. And it's not constitutionally tolerable. But the relief requested rests on the Texas recusal rules. At a minimum, the circumstances counsel strongly in favor of referring this motion so that a different judge decides both recusal and post-trial proceedings, including a timely motion for due trial. Separately, and in the alternative, to the extent the motion for new trial requires fact-finding on courtroom capacity, the volume of media requests, public seating and its rotation, the feasibility of an audio feed, and the reasonable alternatives were rejected. The court's own public statements reflect that it possesses personal knowledge of dispute evidentiary facts concerning the proceeding and independent circumstances that reinforces recusal. Okay. Mr. Anthony requests that the Honorable Judge Roach, within 3 business days of the filing of this motion, either sign a file in order of recusal or sign and file an order referring this motion to the presiding judge of the First Administrative Judicial Region for assignment of a judge to hear and determine it. Because this motion is filed after evidence was offered at trial, Mr. Anthony recognizes that Rule 18A F2B and not Rule 18A F2A governs, so that the respondent judge may proceed unless stayed. Mr. Anthony therefore further requests that the presiding judge of the First Administrative Judicial Region or the assigned judge immediately enter in interim order under Rule 18AG4, staying any ruling on the motion for a new trial until this motion is determined, and set this motion for hearing as soon as practicable. so that a neutral judge may hear and rule on the motion for new trial before the court's authority expires. Mr. Anthony seeks this expedited determination not to delay, but to permit a neutral judge to decide the motion for new trial within the time the law allows. Time is of the essence. The court's authority to rule on a motion for a new trial expires by operation of law on the 75th day after sentencing, and that deadline continues to run during referral and reassignment. Mr. Anthony therefore respectfully requests that referral, assignment, and determination of this motion proceed on an expedited basis so that the judge to whom this motion is assigned may hear and rule the motion for new trial before it is overruled by operation of law. By separate cover, Mr. Anthony has requested expedited assignment from the presiding judge of the First Administrative Judicial Region. Okay? And then there's the prayer, wherefore premises considered, Mr. Anthony respectfully prays that this motion be granted, that the Honorable Judge Roach sign an order recusing himself, or in the alternative, refer this motion to the Honorable Ray Wayless, presiding judge of the First Administrative Judicial Region, for assignment of an impartial judge to hear and determine this motion and Mr. Anthony's motion for new trial, and that Mr. Anthony have such other and further relief to which Mr. Anthony may be justly entitled. Okay? And this was written by Mr. Russell Wilson the third. Okay? Now, it may have come to your attention if you are following me on official That Girl Henny on my Instagram. It may have come to your attention that I had a little bit of information. Okay, it's a little bit of information that is now beginning to circulate out. Okay, and that is Judge Roach. Now, there was a little bit of a debate that was going on, okay, about the authenticity of this particular document. But it turns out that the document is accurate and true. So let me go ahead and let me get this up here for y'all so y'all can see what the heck I'm talking about. Because I know you're like, Henny, what the hell? What the helly? All right, we're going to get this document up here for you so you can see it for yourself, because Judge Roach, yeah, he said he ain't going nowhere. He ain't going nowhere because he can't be stopped now because it's bad boy for life. All right, so as you can see, this is from Judge Roach. And it is an order of referral or motion to recuse. And it says, the motion to recuse having been presented to me in the above styled and numbered cause, I respectfully decline to recuse myself and request the presiding judge of the First Administrative Judicial Region to assign a judge to hear the motion to recuse. Here's my thing. Here's what I already see coming, okay? Maybe y'all see it coming too, maybe y'all don't. And if y'all don't, then I apologize for raining on your parade. But at least I'm not raining on your parade and telling you, you know, that it's rainwater and it's piss. It's really rainwater, darling. I have a feeling that this, okay, so this is the script for the television interview that they did. I'm not going to read that, all right? We can watch it. I could play it for y'all, which I think I'll do. But we're not going to read that. But we are going to read this affidavit of Russell Wilson, if you give me a second. I have a feeling with everything that is going on that they are going to try to play run the clock out. I don't know of the connections or affiliates. I'm not from Texas, okay? So I don't know of the connections and affiliations that go on and how far they reach, and if, you know, judges that are in the appellate court have a relationship with the judges on the everyday level. I don't know what they would be called, just the judicial trial judges. I don't know what those relationships or those ties look like, okay? But I'm telling you that I believe they're going to play a game to try to run this clock out. And I'm going to be pissed if that happens. But before I make any further comments, let's read what Russell Wilson II, I called him third, my bad, the second, has said in his sworn affidavit, okay? It says, before me, the undersigned authority on this day personally appears Russell Wilson II, who being by me duly sworn, deposed and stated. My name is Russell Wilson II. I am over the age of 18 years, of sound mind, and in all respects competent to make this affidavit. I have personal knowledge of the facts stated herein, and they are true and correct. I am lead counsel of record for defendant Karmelo Anthony. In the above styled and numbered case, I make this affidavit to authenticate the following exhibits, each of which I have personally reviewed. The same exhibits are offered in support of both defendants' motion for a new trial and brief in support of defendants' verified motion to recuse. Because the two motion numbers are exhibits differently, I identify each item by its designation in each motion. Okay, so then he puts in there what he has submitted. Okay. So it goes on to say the transcript for the new trial. All right. The gag order. So this is everything that he has put in here. So here is Exhibit B, the order prohibiting extrajudicial statements. This is the gag order. All right. I said we were going to read it. It says the court finds that extensive pretrial publicity poses a serious risk to the fairness of the trial. Pursuant to the inherent authority of this court and consistent with the United States and Texas constitutions, the court orders the following. Parties subject to the order. This order binds the following individuals and entities, covered persons, all parties to this action and their attorneys, witnesses, expert consultants, agents and spokespersons, law enforcement personnel, courthouse, court staff, court appointed officials. Okay, here are the prohibited activities. Unless first approved in writing by the court, no covered person shall make any extrajudicial statement that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness, discuss evidence anticipated to be introduced at trial, identifies or comments on jurors, jury selection, or deliberations, intends or is likely to influence public opinion or potential jurors. The restriction applies to statements made via any public medium, including traditional news outlets and social media. So they couldn't even speak out on their social media platforms, okay? Permitted communications. Allowed communications include procedural announcements, hearing schedules, court filings, statements required by legal or ethical duties, advising clients of their rights. Court findings. Media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. Alternative measures, venue change, jury screening, and sequestration would be inadequate alone. Narrowly applied speech restrictions are necessary to protect juror impartiality. Okay, duration. The order shall remain in full force until verdict or until further written order of this court. All right, sanctions for noncompliance. Any violation may result in contempt, fines, attorney discipline, or other remedies as the court judges appropriate. Notice and certifications. Within 7 days of this order, counsel for each party shall serve a copy on all covered persons and file a certificate of compliance confirming the notice. And that was signed by Judge Roach on July 28th, 2025. Okay. Now, this is getting into the FAA. This is another statement that Judge Roach made to this person, Brooke Taylor TV. It says, Judge Roach tells me that he released the evidence because, quote, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency, end quote. He keep using that word transparency, don't he? Now, here's the letter that he wrote. He says, to the members of the Collin County family, as the presiding judge of the 296th District Court during the recent trial of the state of Texas versus Karmelo Anthony, I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its most fundamental, responsibility, ensuring the fair, orderly, and secure administration of justice. Trials that attract significant public attention require extraordinary preparation behind the scenes. While much of the public focus on naturally directed towards what occurs inside the courtroom, the truth is that the work of administrating justice depends upon the collective efforts of many people, most of whom serve quietly and without recognition. I extend my deepest appreciation to the Collin County Commissioner's Court for its unwavering support and commitment to ensuring that the resources necessary to conduct this proceeding were available. I am equally grateful to our Budget Department, Information Technology Department, Human Resource Department, Auditor's Office, CSCD, Public Works, and Facility Department, with each of which responded to challenges with professionalism, flexibility, and willingness to do whatever was necessary to meet the moment. I offer special thanks to the district clerk's office and jury service staff for their tireless effort in managing an enormous logistical demands associated with trial selection and trial administration. Their work ensured the citizens called to serve were treated with dignity and respect throughout the process. I also wish to recognize the extraordinary efforts of the Collin County Sheriff's Office, whose deputies and leadership devoted countless hours to maintaining the safety and security of all participants while preserving the integrity and decorum of the judicial process. My gratitude extends. He's long-winded, ain't he? You got a lot to say for somebody who ain't supposed to be saying nothing. I'm just saying. My gratitude extends to the Texas Department of Public Safety and to our law enforcement partners from the McKinney, Allen, Fresco, Plano police departments. Their collaboration, planning, and visible presence provided reassurance and protection to all who entered the courthouse. I likewise thank the Collin County and McKinney Fire Marshal offices for their expertise and assistance in ensuring that appropriate safety protocols and emergency preparations were in place. I would also be remiss if I did not recognize my fellow judges in Collin County. Throughout these proceedings, they modified already demanding schedules, adjusted their own dockets, and accommodated the unique needs of this case without hesitation. They understood that ensuring the orderly administration of justice in one courtroom often requires sacrifice and flexibility throughout the entire courthouse. Their willingness to loan members of their staff, including their invaluable bailiffs, provided critical support and exemplified the professionalism and spirit of service that defined our judiciary. I'm deeply grateful for their friendship, cooperation, and steadfast commitment to our shared mission. Most personally, Jesus Christ, he's acting like he was running the damn Diddy trial, like this shit went on for 3 months. It was a week. Your trial was 1 week long. Let's continue. Most personally, I want to recognize the remarkable staff of the 296th District Court. Their hours-long attention to detail, patience under pressure, and steadfast commitment to public service was indispensable. They represented this court and this county with excellence. Finally, to everyone else who played a role, whether through planning meetings, operational support, communications, security preparations, technical assistance, administrative coordination, or simply a willingness to answer the call we needed, please know that your contributions mattered. The public often sees only the final product. I had the privilege of witnessing the countless acts of professionalism and teamwork that made this final product possible. Where's the wrap it up from Dave Chappelle? I need the wrap it up box. Like, wrap it up. The administration of justice is one of our community's most solemn responsibilities. This trial demonstrated what can be accomplished when dedicated public servants from different offices and agencies work together towards a common purpose. Regardless of title or assignment, each of you contribute to ensure that the process was conducted fairly, safely, and with dignity to our citizens deserved. It has been one of the greatest honors of my judicial career to serve alongside individuals of such character and professionalism. On behalf of the 296th District Court, thank you for your service, your sacrifice, your unwavering commitment to the people of Collin County. With sincere appreciation, Judge John Roach. Say what? It sounded like a retirement letter. Yeah. He act like he had Jay-Z, Dee Dee, R. Kelly. Like he had one of them up in here in his courtroom. And that this trial took 3 long months. With massive crowds, and that they had to use 4-5 overflow rooms just to accommodate the trial, But I see what they're saying when they saying what they're saying. Like, sir, you can't be impartial. But when we get to this next piece, where is it? Because Mr. Wilson, I must have passed what Mr. Wilson had to say, because there's an affidavit. Oh, wait a minute. I don't think it's in here. Yeah, it's not in this one, but you know where? What I'm looking for is over here in the new motion. The motion for the new trial. I got a little highlighting that I did. I colored a little bit today. I felt very productive coloring, so leave me alone. All right. When we get to the motion for new trial, let's talk about transparency here, okay? Because this right here says the substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conferences with the court, including May 21st, 2026 conference in chambers, at which the parties' evidentiary understanding was described to the court. The evidentiary understanding is actually the gentleman's, okay, that was discussed in chambers. All right. And May 29th, 2026 meeting addressing trial security and scheduling occurred in chambers outside of open court. No reporter's record of them exists. A matter the hearing will confirm. So this hearing that they're asking for is going to confirm that. But I can show you that. I can do even better. Let me get to it. Because what's being said is also being shown, okay? So we're going to get to this schedule so y'all can see that them meetings, yeah, they wasn't written. Not written. They wasn't documented. And see, I'm going to tell you something. When it comes down to any type of meeting that goes into chambers, the stenographer usually goes in there. How do I know that? Because when they did that at the Diddy trial, stenographers went into the room with them. That's how we know what was being said at the sidebars. Because when they had a sidebar, the stenographer was still typing. So if you had no stenographer there, then you have nothing on record. So I want you all to take a gander at this right here. So you see, it says 4/2. This is when the arrest happened, okay? April is the 5th month of the year, just so you know that. Between April 15th and June 24th of 2025, there's no record of any meeting. And as you scroll down here, you don't see any pretrial meeting. You don't see any meeting in the judge's chambers. You don't see none of that. And then as you see, it goes on. And then we get into 2026, where subpoenas have gone out. Okay? Subpoena returned. Now, when we get here to May of 2026, let's go. Let's make sure. Let's be fair now. You got all these subpoenas that went out in May. Subpoenas. All right? But you don't see any pretrial motions being filed. You don't see any conferences being held in the judge's chambers. You see no mention of any of this. You just see subpoenas going out. But over here, there was pretrial work that was done. There were meetings that were being had. And there's no record of them at all. No public record. The public docket disclosed no motion in limine and none of the substantive pretrial litigation that in fact occurred. Filings that were hand-delivered rather than filed in the district clerk's public record. A member of the public who examined the document before trial would have found no hearing to attend and nothing to read. But wait, there's more, because if you remember, this is what Mike Howard's thing was all about, okay? It says the secrecy outlasted the verdict, okay? You want to talk about transparency. The secrecy. First, there's a second letter in this first sentence, okay? And the sentence only has 5 words in it. The secrecy outlasted the verdict. Trial counsel withdrew on June 10th of 2026. Appointed appellate counsel was then replaced. The present counsel was substituted in on June 23rd, 2026. All while the 30-day deadline to this motion ran. The reporter's record remained wholly untranscribed. I'm going to read that again. The reporter's record remained wholly untranscribed. So on June 23rd, the trial ends June 9th. On June 23rd, when Russell Wilson and the Dream Team step in for Karmelo Anthony, the reporter's record, the stenographer's record, remained wholly untranscribed. Not partially untranscribed. The whole thing is not transcribed, which is why we don't have any transcripts yet. And the pleadings and case files sat in the court's chambers rather than in the district clerk's public records, sealed by oral order. Stop right there. We're going to stop right there. I said we stopping right there. Why are the transcripts not transcribed? Why are the pleadings and case files sitting in the judge's chambers, not in the public district clerk's office where the public records can be given to you, where we can pull them offline? They're in the judge's chambers under an oral order. But he's on here talking about transparency. He released what he released as far as evidence, the video and all of that, the photos and all of that. in an effort to be transparent. Yet you the reason why the transcripts ain't out. So we can't hear what was going on. We don't even know if the stenographer was in the room when they was having these secret meetings. We can't say what was said in court because it ain't been transcribed. That's why there ain't no scripts. See, people been saying, oh, we don't have no transcripts because they asked for it in the appeal. And guess what? I'm one of them people that was saying that. So that voice goes for me too. So don't nobody get butthurt because I was saying it. I was saying it too. Because that's what I thought. And it was because of the appeal. And it turns out it's because it ain't been worked on. Okay? So it goes on to say, at a conference on June 29, 2026, the court advised that the entire court file be sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in chambers. Excuse me, how you gonna tell the lawyer who's representing the client who needs the transcripts and the files for an effective appeal and request for new trial that they can't have the record? Oh, but wait, there's more. Let me just get to this document over here and this evidence so I could pull this up for y'all. Because we're going to read what Russell Wilson had to say. Okay? Because Mr. Wilson gave us some insight into some things. Here we go. Here we go now. Okay? Russell Wilson certifies and states as the following. Okay? This is a certification of counsel. All right? We're going to skip on down all of them. Well, no, we're not. Okay. I am the attorney of record for defendant Karmelo Anthony and his post-conviction motion for new trial in the above captioned cause. I am licensed to practice law in the state of Texas. I was substituted in as counsel on June 23rd, 2026. I make this certification of my own personal knowledge and the facts stated below are true and correct. On June 29th, 2026, I attended a conference with the court in this cause. Counsel for the state and co-counsel for the defendant were also present. Let me zoom this in a bit so everybody can see what I'm saying. At the conference, the court advised the parties that the entire court file in this cause had been sealed by oral order. The court advised that the file was, in essence, maintained as a paper file that was not available to the public and that it was kept for inspection in the court's chambers rather than the district clerk's public file. They sitting in Judge Roach's chambers. The files, the motions, that handwritten agreement that was drawn up on a bogus document that Mike Howard talked about is sitting in Judge Roach's chambers. The untranscribed court record from the stenographer is sitting in Judge Roach's chambers. Are you hearing me? The court advised that there was no written order sealing the court file. No public notice, open hearing, or finding accompanied the sealing, and I'm aware of no written order authorizing it. The court would not permit me to review the court file unless I agreed not to disclose the information contained in it, and the court would not provide unconditional access to the file. I responded that I could not agree to withhold information that I had not yet seen. Stop. How is he going to agree to withhold information that is detrimental to the case for Karmelo Anthony to get an appeal and request a new trial? These are documents that are detrimental to his appeal and for his request for a new trial. But yet we're playing hide and seek with the documents and keeping them in Judge Roach's chambers. Yet Judge Roach is talking about transparency is the reason why he released the evidence, photos, and the videos, because the public wanted to know. I left the conference without reviewing the court file, and I advised the court that I would be back would be back in touch with it. I informed the court that I intended to file a motion for a new trial. I further advised the court that I had not yet decided whether to file a motion to recuse. This certification recounts certain statements made and events that occurred at the conference. It is not intended as and does not purport to be a complete recitation of the discussion with the court. It is offered for the limited purpose of establishing the necessity of an evidentiary hearing and of addressing the availability of the court file to counsel during the period of filing defendant's motion for new trial. Okay? But you won't step down and recuse yourself, sir. You saying you refuse to recuse and screaming transparency, and you think that you're going to be able to sit here and continue on and preside over the new trial or do the hearing? No, you got to go. Okay? I'm going to read a little bit more. 2 days after imposing sentence, the trial judge gave a televised interview defending restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he does sometimes thinks maybe he should have at least audio streamed or something so people could hear it, and explaining that he declined to do so because people are going to distort whatever happens. So what's the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it is important for me to provide transparency." You telling Fox News that it is important for you to provide transparency, yet you are not providing transparency. Okay, now let's skip to my Lou all the way down here. Okay, now that the trial is over, blah 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 blah. In a public letter on June 17th, he thanked the other judges of the county for adjusting their own dockets to accommodate his trial. At minimum, arising a fact issue about available courthouse spaces, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Because the reporter's record of the trial has not been prepared. I'm going to say that again. Because the reporter's record of the trial has not been prepared. Let me put my glasses on so y'all know that I know what the hell I'm saying. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed, and because the case file has been held in chambers rather than in the district court's public record, the recitation above is drawn from the indictment, the court charges, the public docket, the court's own orders, and public statements, the attached affidavits and declarations, and counsel's knowledge. That's where they're getting this from. Defendant will offer evidence at the hearing in support of the grounds timely raised herein. I'm going to go back and I'm going to say that shit one more time. One more again. Let's read the whole thing. Okay, let's read the whole thing from the top. Not even from the top. Let's just go here. In a written statement to Fox News, the judge added, "Now that the trial is over, it is important for me to provide transparency." And in a public letter of June 17, 2026, he thanked the other judges of the county for adjusting their own docket to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Because the reporter's record of the trial has not been prepared, the office reporter has advised counsel that no portion of the trial has been transcribed, and because the case file has been held in chambers rather than in the district court's public record, the recitation above is drawn from the indictment, the court's charges, the public docket, the court's own orders, I mean, the court, the court's own orders, public statements, the attached affidavits and declarations, and counsel's knowledge. They are doing this off of everything but official transcript. But what did he say to Fox News? Now that the trial is over, it's important for me to provide transparency. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial had been transcribed because the case file has been held in chambers rather than in the district clerk's public record. So all these reasons that have been given as to why Judge Roach should be recused, that is yet another one as to why he should be recused, as to why he should not remain over this case. He needs to go. Okay? This is his response. That he declines to recuse himself and requests the presiding judge of the First Administrative Judicial Region to assign a judge to hear the motion to recuse. He got to get up out of here. He got to get up out of here. This judge, he's supposed to be retiring. Oh, yeah. And let me just drive this point home. For everybody that is out here talking about the judge left, the judge retired, he did not. That was a lie. People have twisted so much when it comes down to these court cases. It's not even funny. The man is due to retire in 6 months. He was still on the bench. He's the one who let Jake Lane go. As you can see, he just responded to Karmelo Anthony's case, asking him to step down. And he basically said, I'm not going to step down. Make me step down. He needs to go. He's fruit from a poisonous tree. This boy deserves a fair trial. And anybody saying that his trial was fair and just, you're delusional. And that's me being polite because there's something else that I would rather say, but I am trying to move in a professional manner. But either way it goes, y'all let me know what y'all think down in the comment section below because, yeah. Let me just say this before we end this video. I pray like hell that this does not become a good old boys type of a thing. Remember when I said earlier that I hope they're not going to push this boy's date around to try to drag it out so that they miss the date? The reason I said that is because the judge has already deemed this case done. Not only has he deemed this case done, he has now sent it back for another judge to oversee the recusal. And we don't know how long that's going to take. But the clock is still ticking. The clock didn't stop ticking because he changed attorneys 3 times. The clock continues to remain. So now it's, will they beat the clock? Or will they run out of time? Because in the 75 days that they had from June 9th, they've already lost 30. They've already lost 30. And time is ticking quick. So I hope they don't play no good old boy games. And Karmelo ends up getting his new trial and Judge Roach gets told to step down. Because the more we read up on this case, the more diabolical it gets. That's going to do it for this video. Y'all let me know what y'all think down in the comment section below. Be sure to like, comment, and subscribe. Hype the video if you can. Thank you for watching. If you stayed all the way to the end, then drop me some white hearts, butterflies, and Henny glasses in the chat. And I'll see y'all in the next one. Peace, everybody.
Because I